Welcome to This Explainer, everyone. Today, we are going to unpack a really high-stakes and deeply controversial role within family law. We're talking about guardians ad litem in private domestic child custody cases. It's a system that wields just an immense amount of power over families, yet it remains incredibly misunderstood by most people. It all boils down to one haunting question. In a bitter custody battle, who actually speaks for the child? Think about it. When parents are basically at war over custody, the child is often caught right in the crossfire. Both parents have their own attorneys fighting for them, but the child's voice, and more importantly, their best interests, need a completely independent advocate. To get a grip on this complex legal landscape, here is the agenda for our explainer today. 1. The private custody wildcard. 2. When guardians go rogue. 3. Who protects the protectors? 4. Reforming the guardian system. And finally, 5. Strategies for custody battles. Let's jump right in. Section 1. The private custody wildcard. Okay, let's start by getting really specific about what this role actually entails. In private domestic child custody cases, and we're specifically omitting state-run Child Protective Services or DSS dependency cases here, a guardian ad litem, or a GAL, acts as the absolute eyes and ears of the court. When two parents are locked in a private dispute, the GAL is appointed to investigate and figure out exactly what is in the best interest of the child. And honestly, the things they are allowed to do perfectly illustrate why there's such a wild card. Unlike a judge sitting on a bench or a typical attorney, a GLL has this entirely unique authority to step right out of the courtroom and directly into a family's private life. We're talking about entering homes multiple times, observing how parents and kids interact, evaluating third-party caregivers, and asking parents point-blank questions about their disputes. They're gathering the raw, intimate, everyday data that a judge simply cannot see. But as you might guess, this level of intense investigation doesn't come cheap. To put that into perspective, let's look at the 2001 high-asset divorce case, Patel v. Patel. That case involved a $2.6 million marital estate, and the wife was ordered to pay 14% of the GAL fees. We're talking tens of thousands of dollars out of pocket. It really highlights the massive financial burden these appointments place on litigants. You're basically footing the bill for a private investigator and an attorney rolled into one to scrutinize your life. Which brings us to Section 2, when guardians go rogue. So what happens when immense power meets a lack of oversight? Well, immense frustration follows for both the parents and the family lawyers. South Carolina family lawyer Robert Rosen famously described GALs as expensive, unnecessary, officious intermeddlers. And honestly, behind closed doors, a lot of family law attorneys agree with that. They often view GALs as expensive wildcards who just add their own subjective opinions, kind of based on their own worldviews or even their own childhood baggage, into the litigation. The ultimate nightmare scenario in any private custody battle is a slipshod investigation. Imagine a rogue GAL who just develops a personal dislike for one parent right off the bat. That bias can color their entire investigation. They might start ignoring crucial evidence and gloss over important issues that they are uniquely supposed to be analyzing. And because judges tend to place so much weight on these supposedly impartial recommendations, a biased GAL can literally destroy a parent's case. On top of that, all this intimate access creates some major ethical landmines. Because GALs gather incredibly confidential information, the South Carolina Bar issued Ethics Advisory Opinion 04-08, which explicitly warns against GALs switching sides later on. For example, a GAL absolutely cannot represent grandparents seeking custody against biological parents they previously investigated. Why? Because that guardian was given access to deeply personal secrets under the guise of being a neutral fact finder. Section 3. Who protects the protectors? Now, before we entirely condemn the GAL system, we really need to flip the script for a second. We have to look at the terrifying vulnerabilities faced by the guardians themselves, because it is definitely not an easy job. Good GALs regularly endure deeply personal attacks, defamation in open court, and sometimes even physical danger, usually without any real protection from the family court. Attorney Gregory Foreman has talked about the staggering reality of going into the homes of highly unstable individuals or serious substance abusers. Plus, unhappy litigants often use invasive discovery tactics to target a GAL's own family members or maliciously expose their private medical histories, all while the GAL is begging to be paid at what's often half their normal hourly rate. This is a massive problem. In a recent South Carolina bar training session, Megan Dell and Almond Barron hit the nail on the head, asking, the GAL protects the kids, but who protects the GAL? The family court frequently fails to shield gals from these kind of vindictive allegations and severe privacy invasions. And here is the breaking point. This toxic duality, furious, desperate parents on one side and totally unprotected guardians on the other, proves the current ecosystem is just fundamentally broken. Dedicated, highly competent attorneys are simply walking away from GAL work. The physical risks and the character assassinations just aren't worth the reduced pay. And when the good ones leave, who does that leave the system to? Let's look at Section 4, Reforming the Guardian System. Recognizing this absolute crisis, lawmakers in South Carolina are taking action. The 2025 to 2026 legislative push, specifically through Bills 3103 and 3622, is aiming to radically overhaul the requirements. They are proposing a shift from allowing laypeople to serve as GALs to requiring them to be licensed, accountable attorneys in these private domestic disputes. So why the sudden push? Well, under current statutes, laypeople can dictate a family's entire future with shockingly low qualifications. As it stands right now, you just need to be 25 years old with a high school diploma, sit through 9 hours of initial training, 3 hours of procedure education, and watch 3 court hearings. That's it. That is an incredibly low bar for someone tasked with untangling deeply complex, life-altering private custody battles. Now, Bill 3622 does carve out one narrow exception. If both parents are navigating the family court system totally unrepresented by counsel, a layperson might still be appointed as a GAL. But for cases where attorneys are actually involved, the state is pushing really hard for the guardian to be a licensed attorney as well. This would inject a desperately needed standard of legal accountability right into the role. Finally, Section 5, Strategies for Custody Battles. So while we wait to see what the legislature does with these bills, what can parents and attorneys do to protect themselves from a rogue or incompetent GAL right now? Experienced family law attorney Gregory Foreman says you need to completely abandon what he calls witness-based requests. Just handing a GAL a list of your friends and family is basically useless. Everyone knows your friends will say nice things about you, right? So a GAL can easily justify just ignoring those calls. Instead, you have to use highly specific issue-based written investigation guidelines. By putting these issue-based requests in writing at the very start of a case, you are building an undeniable paper trail to hold that guardian accountable. For example, instead of just saying, "Hey, talk to my mom," you write, "One of the issues in this case is my client's successful track record of co-parenting an older child. We request you meet with the mother of this child to investigate his track record." You are giving them a very specific material fact that they have to verify. And this right here, this is the tactical masterstroke. You conclude your written request with this exact language. If I do not hear back from you, I will assume that you have no issue undertaking the investigation I propose. That forces the GAL into a corner. They either have to do the actual work, officially object in writing, or face an absolutely devastating cross-examination at trial later on for failing to investigate a critical, agreed-upon issue. This whole tactical approach ensures that if a gal does go rogue, the judge is going to see a clear, documented record of their failure to investigate. If you just complain at trial, it usually just sounds like sour grapes, like you're just mad you lost. But with a solid paper trail, you can neutralize their biased testimony by definitively proving incompetence or bias right from day one. As South Carolina attempts to mandate higher standards for guardians ad litem, swapping laypeople out for licensed attorneys, we are really left with one profound thought. Legal reform, better training, and sharp trial strategies, they can absolutely address the symptoms. But we have to ask ourselves, is legal reform alone really enough to heal the bitter, deeply human fractures of the private family court system? Thank you so much for joining me on this explainer today, and I really encourage you to keep questioning how we protect the most vulnerable voices in our legal system.